Good afternoon, everyone. Welcome to today's webinar. You're welcome to say hello in the region that you are from. Always good to just give a shout out and see to join this very relevant discussion with us. You can do it in the chat. You can give a shout out. As the people are joining, see that we're filling up. Just for practical reasons, if you, through the course of the webinar, if you do have a question for the expert, the panelist, you're welcome to address your question in the Q&A section at the bottom of your screen. We have allowed for a Q&A session after the formal discussion, and we will gladly take your questions then and see how much we can get through. Or after, if not, we will just take your details and we will make sure that we get your relevant answers through to you. I see Cape Town is in the house. Welcome, Victoria and Bronwyn. Glad to have you here. Chantel from Randburg, welcome as well. Leia, also pleasure having you here. Welcome. Hope that this will be a fruitful afternoon for you and your business. Impangeni. Good afternoon, Verona. Cape St. Francis, welcome. Namibia in the house, welcome. Glad to have our neighbors in here as well. Rudeport, I think you can hear my voice because I'm close by. Rondebosch, welcome, Laura. Catherine. Welcome, Nashua. Close to our offices there in Woodmead. Pleasure having you. Trinita in Sandton, also welcome. I am going to allow for half a minute more, and I'm going to use the time to introduce my colleagues and my expert for today's session. I'm joined by my colleagues in LexisNexis, Vinette de Wet, who is a manager in the risk management solutions, as well as Alan Mouton, also a manager in the risk management solutions. Ellen is our sales data analyst, also assisting with a lot of the content. And of course, Cedric Effendi from Masthead, our expert, who's going to take us through compliance and practical help where this is needed. My name, Melinda Steinman. I head up the sales in the business software solutions at LexisNexis South Africa. And I think I'm going to start the session off by saying that, and we just spoke about it in the preparation session, 2024 has been a year filled with intensified focus on complying with the FICA Act, coupled with updates on financial crimes and the compliance landscape and many more. However, it all comes down to the G word, right? Which we otherwise known as the grey listing. Towards the end of 2022, the Government Gazette published changes to the Schedules 1, 2, and 3 of the FICA Act to close the gaps in anti-money laundering and counter-financing for terrorist coverage in South Africa by expanding the reach of the FICA Act. Whilst this significantly increased the number of people and firms that are now identified as accountable institutions who are now need to comply with the FICA requirements, it has also provided FICA with additional valuable intelligence across a broader range of industries, financial and non-financial, to cover the expansion of the reach of the Act, and also to help them combating those against those who have criminal intent on those specific organizations. As an accountable institution, your responsibility to comply with FIC regulations is essential. Yet, even those with a strong knowledge and understanding of the financial or the legislative requirements struggle to implement the necessary measures. The risk of missing key requirements or even recent updates will have devastating results on your business, reputational, and financial repercussions. So in this webinar, our expert, Cedric Effendi from Masted, will provide a clear breakdown of what your requirements are to be compliant with FIC. He will also give us some practical advice to meet your obligations and assist you to stay compliant. So with that said, Cedric, I'm excited to get stuck in the detail. So over to you.
Thank you very much, Melinda. Much appreciated. Yes, to everybody joining the session, welcome. Thank you. It's great having you here. Great spending time with you. I think, as Melinda emphasized, that this over the last couple of years have become a very important topic, and something that unfortunately we cannot shy away from anymore. We need to embrace this. We need to take this piece of legislation. We need to understand it, and we need to apply principle when implementing this legislation within our organization. Yes, we have the letter of the law, which we should uphold at all times. But when it comes to FIC, it has become such an intense piece of legislation to actually principally apply it in. And sometimes one does need a little bit of assistance, because it is not back into, we're not back in 2014 or 15 anymore. We've moved on quite significantly. I have very limited time. It's only an hour session. I've got 45 minutes. I'm going to do my best to give you a high-level overview. I cannot touch on all points. For me to touch on all points when it comes to being fully compliant with FIC will have to be several discussions, engagements. It takes a lot of time to understand what is actually required. So my idea is just to give you a high-level overview of what is required to be compliant, especially moving into 2025. We've seen changes 2024. Well, we've seen changes since 2022 already, but 2023, 2024. But then, of course, also in a position where next year we're getting a visit from the Financial Action Task Force again. And there will be continuous ongoing changes in this piece of legislation until we get to a point. I don't know if we will ever get to a point where we now say we're finished. Because FIC is about protecting your organization against money laundering, terrorist funding, proliferation, financing. That's what it's about. It's about giving you tools and guidance to do that. Yes, it is legislative, but it's something that you've worked for, you've built up a legacy, you want it to continue. And you've got to do what it is that you possibly can to protect that. So just to start off, there's been a lot of articles floating around the last couple of weeks, even months, about certain accountable institutions receiving quite hefty fines. I'm sure some of you have read about these fines. There was just an appeal case now where it went to the FIC appeal board for a specific accountable institution where the penalty was 7.8 million rand. The reason for me saying this is not to use any form of scared tactics around. Yes, nobody wants to pay that money. Nobody wants to get a fine. But what I want to highlight around that whole scenario and the stance that the FIC is taking, if you read the articles and you read the communication and you look at what the FIC's executive manager for compliance and prevention said, Mr. Christopher Milan, clearly said in the article that we have used many public platforms and pleaded with people to comply, literally pleading with them, please do comply with this legislation. And if you read, if you read between the lines, we're definitely in a position now where we can't stick our heads in the sand anymore. We need to embrace this, we need to do it, and we need to do it to comply. And that's why we are here. That's why LexisNexis is creating this platform for us to share information so that we can make sure that you as an accountable institution remain compliant, and you protect your business, and most importantly, you protect your reputation. Okay, so let's start off with quickly. We're going to have a little bit of an introduction. So we're going to go a little bit back, and then we're going to move forward. We're going to talk about a risk-based approach. We're going to talk about the requirements of FIC. We're going to talk about reporting, of course, which is very, very important. And then, of course, we'll finish off with the governance. So under our introduction, we'll look at legislation. We'll look at relevant anti-money laundering legislation that works together. And then, of course, we'll quickly just touch on the Financial Action Task Force, and then, of course, what it is that they do. So you all know, going back, the FIC Act was established under the Act 38 of 2001. And then, of course, we had amendments, which was done in 2017. And this is where everything changed for us. This is where we moved away from something called FIC internal rules to something called a risk management compliance program, which I'm sure a lot of you have heard about. If not, I will definitely be talking about that today. Then, of course, with that, there's a collaboration with the Prevention of Organized Crime Act, FICA, and of course, also what we refer to as POPTATARA. There's 4 main objectives that FICA have, just 4, okay? That's to identify proceeds of unlawful activities, identifications of persons involved in laundering activities, combating money laundering, and implementation of financial sanctions to resolution adopted by the Security Council of the United Nations. Okay, so simple, what it is that they want to achieve, but unfortunately not that easy to try and always do this on your own, because you have to take a lot of things into consideration. Okay, so why did we firstly amend? Why was it necessary back in 2017? Okay. First of all, we needed to address the regulatory gaps and to enable compliance with best practice, align ourselves internationally, and of course, being part of the Financial Action Task Force as well. We needed to strengthen our customer due diligence, especially in terms of beneficial ownership and people in politically exposed positions. Okay. We need to introduce an adaptable risk-based approach to identify and verify customers, and improve the sharing of information among designated entities, and to enhance coordination with crime-fighting capabilities. A lot of the things that I'm going to talk about now and take you through is things that needs to be documented in something which is called a risk management compliance program. Now, ladies and gentlemen, I know that there's a lot of people out there that are saying, I've got a template, I've got a template, I've got a template. I don't want to shut down anybody when it comes to templates. What I want to tell to you, what I want to bring across is, please shy away from just templates. Because if we look at all the information that I'm going to go through now, a template is not going to take you far. You're going to have to apply your mind, and it's going to take a lot of time to implement a risk management compliance program that speaks to your business, your processes, your business risk, and then, of course, taking other things into consideration as well. Just quickly, what happened, if we go back, there's been a couple of changes in the last 2 years or so. We introduced more accountable institutions. There was an updated list published when it comes to supervisory bodies. Providing a list of reporting institutions have been deleted, of course. Changes to reporting timelines and reporting thresholds. For an example, we changed, or that the legislation changed, the 24,999, 2 days, to 49,999, 3 days. So those are some of the changes that we had there. Also, some changes relating to aggregated amounts. When that came in effect was in 2022. And then, of course, changes relating to Anti-Money Laundering, Terrorist Funding Proliferation Framework 2022-2023, because of strengthening certain things. And of course, this was due to the fact that we were put on the grey list. Ladies and gentlemen, don't think that this does not have an impact. It does have an impact, not just on accountable institutions and having more legislative responsibilities that they need to execute, but as a country, it does have an impact. And there's a lot of articles out there that you can go and read to have a look and see what the actual, what is the impact of us being on the list. And only together as accountable institutions, various on different sectors, working together, we can actually come off this list. And hopefully we can do that as soon as possible. But because there was, because of that, and there were some changes in the Act, of course, there were changes that needed to be made in Trust Property Control Act, Non-Profitable Organization Act, Financial, and then of course the FICA Act itself, Companies Act, and of course the Financial Sector Regulation Act as well. There were some changes made there. There was changes made in the definitions around beneficial ownership, domestic, prominent, influential, influential persons, now changed to domestic politically exposed person, foreign prominent public official, now changed to the foreign politically exposed person, and inserting a definition of what prominent influential person is. Talked about additional ongoing due diligence. And then, of course, we were introduced to proliferation financing activities. The reason why I'm saying this is you might have had a RMCP that was compliant back in 2020. If you haven't done any changes, this document should be reviewed annually, at least annually. If your services doesn't change throughout the year and your risk doesn't change. So you need to do that in any case. You can't wait for legislation to change to review your risk management compliance program. But if you haven't done anything since 2020, then there's a couple of things that needs to be introduced in your RMCP, and it needs to be, I wouldn't say reworked, but it needs to be adapted and it needs to be changed. Also, something that was introduced under Section 31 was electronic transfers of money from the Republic of South Africa. Of course, there was a prescribed amount and also needed to be, there's a reporting obligation on that as well. We'll touch a little bit on that, but that's on Section 31 of the FICA Act. And then, of course, not sure if you've heard, something called Directive 8 under PCC 55, employee screening, that employees that work within an accountable institution also needs to not just be screened, that's minimum requirements. But as an organization, you also needed to implement a risk-based approach when it comes to your organization and its employees. And based on that, you need to do certain things. So it's not just about screening. I think there's a lot of people out there when I speak to them say, have you complied with Directive 8? Yes, I've screened all my clients. Okay, well, wait, it's not just about screening. It's about we need to look at also the competency of the individual and the integrity of the individual. How do you do that? What do you do? Of course, when you use automated means, it's so much more easier to do it than if you have to do it manually. And you also need to have a risk-based approach that you need to take when it comes to where does certain people sit within my organization. Okay, and that in itself is a discussion on its own. Okay, and then of course Directive 6 and Directive 7, which unfortunately the Financial Action Task Force and the FIC was not very happy about, because a lot of people, depending on which schedule you fall under, Directive 6 or Directive 7, the deadlines were last year. A lot of people did not meet those deadlines and did not complete the Directive 6 and 7. And when reporting that back to the Financial Action Task Force, was not good news at all. Because, as I say, depending on if you fell under Directive 6 or 7, you needed to log onto the FIC website and go and complete that directive. And unfortunately, a lot of people did not do that. Very important, if you don't have a risk management compliance program, call it your FIC Bible. If you don't have that, you can't actually go and complete that directive, because a lot of those questions, the majority of those questions under that directive speaks to your RMCP. and what is contained in the document itself. How will FIC communicate? For those of you that don't know, very important. Yes, I registered a FIC money laundering officer, call it a FIC compliance officer, call it an anti-money laundering officer. Some people use different terms within their organization. I appointed that individual back in 2018. Okay. Can that person still log in? You need to go and constantly log in. Not just for reporting. If you have nothing to report, you still need to log in to see if stuff is happening, if you can still log in. And then, of course, very important, the person who is assigned as that specific individual, and we will talk about the responsibilities at the end of that individual, needs to make sure that that password and username is not shared with anybody. Nobody. That it's legislated. You're not allowed to share that. But because there's communication that comes to you as an organization, that comes to you as an accountable institution, and you need to stay on top of things. As I've mentioned, directives, they'll communicate via that. There's a lot of public compliance communication that go out. I do roadshows, whether it's live, whether it's virtual. And then, of course, a lot of guidance notes on the FIC website as well when it comes to certain things. You're not sure how to do something, you can go and visit the website. They'll give you some guidance on what it is that you can do. So that's the way that they communicate. So one also needs to be a little bit proactive and reach out to the FIC website, to the FIC sometimes, and not just wait for communication that comes from them. Needs to be some form of mutual relationship there as well. There's 3 stages of money laundering, and this is where the RMCP becomes very, very crucial. We talk about placement, layering, and integration. Now, if you look at your organization, and I'm the one saying to you, I need you to look at your organization, and I want you to go and sit and spend time, and I want you to go and look, how can somebody use your organization to either launder money, fund terrorists, or proliferation financing? And you look at these 3 things. You look at placement, layering, and integration. How can this happen in my organization? Then this doesn't become a template anymore, ladies and gentlemen. This becomes applying my mind around my business risk assessment. Where is my business vulnerable? Because the quicker you can stop somebody wanting to use your organization to launder money or fund a terrorist or whatever the case might be, perform some form of unlawful activity, the better and the easier it is for you as an organization, because that's what it's about. I get different types of conversations. Each and everybody is different. Cedric, I will never deal with somebody like that. All my clients are low. I know everybody. I've known them for the last 50 years. That's wonderful. And I'm glad you were able to build up solid business relationships with clients. But it doesn't mean that you still, at some point in time, can be vulnerable because you don't know what the future holds. You still need to go and do this exercise. And then from there onwards, implement a risk management compliance program, which speaks specifically to your organization. Okay. We did touch on this. I'm not going to go into this very much in depth, but just to let you know, POCA and FICA, if we look at those legislations, FICA made additions to and revoked certain parts of POCA. FICA and POCA should always be read together because, yes, we have accountable institutions that have a responsibility, but then we also, as South African citizens, have some responsibility if we see things that are not good, and we all need to protect our democracy at the end of the day. The Financial Action Task Force, ladies and gentlemen, if you didn't know, we belong to this organization. We joined back in 2009, not join per se. You cannot join the Financial Action Task Force. You get invited to join the Financial Action Task Force. And if you accept the invitation, which is great for the country because it shows that you want to do something that is good when it comes to money laundering and terrorist funding, you need to play by their rules. They are an intergovernmental body. They have 40 recommendations and 9 special recommendations, which each and every country must comply with. They come and audit countries when it comes to these 40 recommendations and 9 special recommendations. Based on their findings, and it's not just a 1 or 2 or 3 or 4 day audit, it's over a long period of time, they will then release release a report, and depending on what the report is, last one, of course, we didn't unfortunately achieve everything that it is that we needed to achieve. We were placed on the grey list. Bear in mind, yes, South Africa is put on the grey list because of the because of the Financial Action Task Force, but the United Nations, the EU, because of South Africa being put on the grey list, they have their own risk based when it comes to national risk assessment, which is also something that FICA just published, which also needs to form part of your risk management plan if you haven't done so yet. The EU has actually placed us on the blacklist, their blacklist, which makes it very difficult when you want to engage with investors or want to do business with people overseas, and they might be hesitant due to not wanting to engage with someone, whether it's protecting their reputation or their finances or whatever the case might be. So this does have a ripple effect that impacts everybody. A risk-based approach. What is a risk-based approach? Again, I can speak 3 hours just on this, but unfortunately, we only have very limited time. But as an organization, and if you look at your risk management compliance program document, you go and look at section 42, it is required of you to have certain things in that document, documented, personalized to your business. Okay? You can't skip something. For an example, if you don't do electronic transfers out of the country, you know, you can't leave it out. You need to go and say that I'm fully aware of what Section 31 is of the FICA Act, but this does not comply to my business due to the nature of my business, and explain why. Okay, so there are legislative things that need to be in there. But most importantly is, how do you in your business approach risk when it comes to protecting your organization? And if you look at risk, one needs to look at identify, assess, monitor, mitigate, and then, of course, manage these risks. You have risk when dealing with clients. Then, of course, there's something business risk. How can my business be used and how can I protect my business? But then also something that came out this year new is that there was a national risk assessment done based on nationally where there are certain areas of concerns, where your RMCP also needed to be updated. From there onwards, it flew into what we call, sectoral risk assessment. What industry are you working in? And what are the risks within that industry? Is it a higher risk for money laundering and terrorist funding when I'm in certain sectors, or a little bit medium or lower, which also needs to be incorporated into your RMCP. And then eventually breaking it down, we've always had the business risk assessment, but then we also have our risk when it comes to dealing with whether it's a natural person, a legal entity, a partnership, or a trust. So a lot of thinking needs to go in when doing these type of things. So if we look at identifying, what is the process used to identify money laundering, terrorist funding, proliferation? Risk must account for a range of factors, ladies and gentlemen. You can't just go on one factor. You got to look at your business in a whole. And you've got to take a couple of factors into account to determine how will I go about mitigating the risk within my organization. So you would look, for an example, to what are the products that I do? What are the services that I do? What type of clients do I deal with? Do I deal with a lot of complex juristic entities? We all also know that from a beneficial ownership point of view, if you haven't, please, this is important, because the RMCP again must be updated, not just the RMCP, but your process as well. That shareholding has been dropped from 25 to 5%. So if somebody owns 5 or more, that person needs to be identified and verified. And you need to follow your due diligence process, whatever that might be. Again, just on speaking to you about due diligence will take me another 2 or 3 hours. Okay. So you got to look at it holistically when we talk about a risk-based approach. Then, of course, we assess those areas of risk within our organization. So we've got the factors, and then we have the factors that influence the level, when it comes to money laundering, terrorist funding, proliferation risk. And then we look at the products, the services, the delivery channels. How do I deal with clients? Which how do I communicate with them? All of these type of things you need to take into account, because if you put certain measures in place, you can mitigate things. The FIC doesn't want you not to do business with people. There is certain areas where you're not allowed to, and we'll touch on that. The point is not to, if I have a client that is low, medium, or high, to not deal with a high risk client. That's not the point. That's not what they want. They want that when you've identified an individual as a high risk individual, that you do something which is called enhanced due diligence and do the necessary investigations to know who you are doing business with, because that's what it's about. Know who you are dealing business with. And then, of course, also factors that influence level of risk is geographical areas, client indicators, other factors relevant when we look at the influence, prominence, a lot of other things that one needs to look at that applies to your business. That's why using a template is so dangerous. Thinking that, ladies and gentlemen, with all due respect, if you've got a 15, 20-page document, not good news. It's impossible. It's impossible to have that. This is needs to be a fully documented everything that is required from a legislative perspective. So again, how do I go about doing a risk rating? I need to take things into account. For an example, of course, there needs to be some form of scale. And the scale is dependent on the size of the accountable institution. That's why you need to apply your mind. Somebody might give you a template that is built around accountable institutions that are marked from a national risk assessment as high. And you try and follow that whole process, and it's not even necessary, or the other way around. Everything is low, but from a sectoral risk assessment, you are in a higher bracket. It's very, very dangerous going there. And the bigger and the more complex your accountable institution is, the more complex your scale of risk rating will be. Okay, at the end of the day. But accountable institutions, they need to apply their mind at the end of the day. And again, your risks might be today on the 20th of November, this. In 6 months, it might change because you are adding services, or you are adding products, or creating other channels of doing business, or getting referrals from other organizations, entering into partnerships. Then that needs to be updated. Okay. But I also want to just go back. The RMCP needs to be reviewed as well. Even if there's no changes in legislation in your business, it still needs to be reviewed at least annually. But again, depending on the nature of your business and the complexity of your organization, that might have to happen every 6 months. Okay. So we use something which is referred to as a matrix. Again, this is where the holistic approach comes in. There, of course, is a minimum criteria that should be aligned. And at the end of the day, it's not just South Africa that needs to comply with it. It's all the other countries that are part of the Financial Action Task Force. It's not just us. We are a little bit behind other countries when it comes to what they are doing. Because we're talking here about one piece of legislation. This goes a lot deeper as well. If you're starting to add not just fraud, cyber attacks, all of these things, then things become very complicated at the end of the day. We also know that, for an example, cybersecurity is also a big issue currently. Okay. From a monitoring perspective, we do something that, I beg your pardon, we call a due diligence process. So I've taken all my risks into account. I've looked at my business. I looked at the national risk assessment, business risk assessment. Well, first I look at the business risk assessment because that's always been part of Section 42. And then, of course, I look at the sector that I'm in, and then from there onwards, nationally, and I look at all of these things. And then I dim it down to, okay, now I'm going to deal with a client, whether it's a legal entity or a natural person, partnership, trust, whatever it might be. Okay. I will use my risk that I've identified. I will rate the client accordingly, and based on that, I will follow a due diligence process. Okay. Go and look and read why these people are getting fines. They don't have a documented RMCP. They don't have a risk-based approach. They don't do screening of clients. And if you don't have a risk-based approach, you can't follow a due diligence approach. And if you can't follow a due diligence process as per your business, if you can't perform your due diligence process, depending on what the type of entity or client is, you are not allowed to enter into a business relationship with that individual. It clearly says that in legislation. So depending on the risk rating, you will do a due diligence. Might be simplified, might be standard, and enhanced. Okay, so low risk will be a little bit more simplified, medium risk, and please, you've got to look at low, medium, and high. Medium risk, we'll do a standard due diligence, and we will also high risk, we'll do enhanced, and even going above and beyond that, if need be, depending on who the individual is, you might even have to increase your enhanced due diligence and start asking for more documentation at the end of the day. So again, the process itself might sound simple. Applying your mind and sitting and doing this and having the discussions, whether you are a sole prop or whether you have a board of directors and a lot of people, everybody needs to be aware of what is going on when it comes to FIC in any case in your accountable institution. Okay. Know who you are doing business with, please. Know who benefits from it. Understand the nature of your business that you do with the client, and determine when the business with customers should be considered suspicious or unusual. Okay. The management thereof, okay. After I've done that, I've done my risk rating, I've assigned a certain risk to a client, I need to manage these things going forward. Okay. I need to manage my risk successfully. As and when my business change, I need to change. I need to adapt if need be. Okay. Because we sometimes get into a position where we think we're done, we're safe. You might be safe today, but if things have changed, you might not be safe anymore. Okay. So you need to manage these things, and that, of course, is where the review comes in as well. Okay. Look at FIC requirements. We've got 7 pillars of compliance that an accountable institution needs to comply with. As I've mentioned to you before, ladies and gents, very high level. First, you register. You do that on the GoAML system, on the FIC. Training and screening of employees. Very important. Not just training on FIC, but training on the RMCP. Okay. Very important. People forget that. And if you train your staff on an RMCP, there needs to be some form of assessment where you test their knowledge of the understanding of the risk management compliance program, because all employees need to have a copy. Whether you load it on a share folder, OneDrive, email it to everybody, whatever your decision is, everybody must have one. And then that brings us to number 4, must have a risk management, updated risk management compliance program at all time. Record keeping, very important how that works. And then, of course, reporting, which is essential and crucial if need be. Okay. There we spoke about the registration. GoAML, you need to go and register there as an accountable institution. Hopefully all of you have done so. If not, please do so. The employee screening, that was a new requirement that was introduced 31 March 2023. We spoke about that. Don't want to delve into that again due to the nature of time, and I want to stick to my time. But please make sure, as I've mentioned to you before, it's not just the screening. That's the minimum. You still need to follow a risk-based approach at the end of the day. Okay. Then the purpose of training. Why do I need to train my staff? Sorry, I just lost my screen here. I'm just trying to get it back. Here we go. Beg your pardon. Why must I train my employees? Very, very important. Every employee needs to understand this piece of legislation, okay? Because it impacts the business. It forms part of your day-to-day activities when it comes to people dealing with clients. Okay? They need to know what is expected of them. If an employee is not trained on FIC, they are not allowed to deal with clients. Okay? And then, of course, to ensure that every employee is alert of the possibility when it comes to money laundering, terrorist financing, proliferation financing, when something doesn't look good. And then, of course, to ensure that every employee can identify suspicious or unusual activities. Something doesn't look good here at the end of the day. Governance, who's responsible for this? The responsibility of complying with FIC within an accountable institution. You can see there yourself. The FIC Act states that the board of directors or senior management of an accountable institution are now responsible for the compliance with FIC Act and the RMCP. Okay. The accountable institution must have a compliance function to assist the board of directors or senior management in fulfilling their obligation, unless the accountable institution is not a legal person, of course. And you need to assign a person with sufficient competence and seniority to ensure effectiveness when it comes to these functions at the end of the day. Okay, so it's the people that govern the organization. Okay. Risk management compliance program, again, ladies and gentlemen, that is a complete teaching on its own. What everything that needs to go in there. This is very high level, as I mentioned. Go and have a look at section 42, how to develop it, how to maintain it, and what needs to be in there. Just quickly, you must have all your processes documented, because if you ever get an audit, whether it's from a supervisory body or the FIC, they will test your RMCP to the actual process within your organization. It needs to speak to the process. It's almost like, you know, those books that you get, you know, cognitive behavior for dummies. Not that an RMCP is a dumb thing. That's what I'm saying. It needs to be personalized, applied your mind, thinking about it, needs to comply with legislation, and the people around you need to understand what is documented in that RMCP at the end of the day. Okay? In there, of course, you've got your risk ratings, how that works, record keeping, customer due diligence. There's such a lot of things in there. The identifying, the assessing, the monitoring, the mitigating. And then, as you can see there, number 4, an accountable institution will be measured with this document if visited by the FIC representative or a supervisory body. And then at the bottom, it says employees may be interviewed regarding the understanding of their RMCP. I also actually want to say they will. I would rather go on the word they will, because that's what I've experienced in the audits that I've been involved before. Okay. Spoke a little bit about customer due diligence, but what I want to just highlight here is accountable institutions are prohibited from conducting business or concluding a single transaction when the information about a business relationship cannot be understood or obtained. The accountable institution cannot conduct their customer due diligence when the person or entities were identified on the actual United Nations Security Council. Need to walk away. The client is anonymous, and if clients are acting under false or fictitious names, then you don't deal with them. Otherwise, you need to apply your risk-based approach. That's very, very important. But at that stages, you need to walk away or not deal with the individual. This just to give you a little bit of a diagram of how it would look. You would establish an event, verify prospective clients. You would screen, you'll do customer due diligence, scrutinize client information. You'll do a risk assessment depending on what that is, low, medium, or high. You would onboard, you would either deny, and then, of course, bearing in mind that when you deal with high-risk clients, the money laundering, call it the anti-money laundering officer within your organization, needs to sign off on that, whether it's one individual or a board, depending on the size of your organization. Ongoing due diligence is something that people unfortunately sometimes do forget. You need to do something which we call ongoing due diligence. That's when you very much part of an organization where there is business relationships. You decide, again, it's a risk-based approach. On my low, medium, or high-risk clients, I will do ongoing due diligence at these type of intervals. That's just to check and see if the individual originally, if any circumstances within that specific person or legal entity, if anything has changed that might affect their risk rating. So I need to do some more due diligence, or it might even be that an organization goes down from a medium to low. Does depend on what the scenario is. So ongoing due diligence does need to be performed. There's also something called a transactional due diligence. So I've onboarded a client, and every time I, after that, transact with the client, I will then sorry, ladies and gentlemen, can you still hear me? Something happened now. Seems like I've lost some form of signal. Can Belinda, if you can maybe just, okay,
Yes,
perfect.
we can still
Thank
hear
you.
you, Cedric, and we see your screen as well.
Okay, thank you. Sorry, it just went blank. Not sure what happened there, but in any case, let's just go back because it seems like it skipped through a couple of slides. There's also something called transactional due diligence, ladies and gentlemen. As I've mentioned, you onboard a client. If you transact with that client within a period of 6 months, then one needs to perform something called a transactional due diligence as well, just to ensure that it's in line with what you know about the client at the end of the day. Okay. So very important to do that when it comes to your customer due diligence at the end of the day. Record keeping, very important, ladies and gentlemen. Go and have a look at what records needs to be kept. 22A of the FICA Act explains that. And how one should go about, for how long, need to keep records for a period of 5 years. And very important, failure to keep records as stipulated is a case of non-compliance, and unfortunately is subject then to an administrative sanction at the end of the day. Okay. Evidence that are being kept, as I say, you need to make sure, keep all your records when you deal with clients. You need to, what is the nature of the business, the intent, the purpose of the business relationship, source of funds, how you identified that, the amount involved, the currency in which it was dominated, the date of the transaction, everything you will find there, evidence that needs to be kept. And as I say, 5 years after last transaction, I think legal practitioners are now required to do so 7 years, if I understand that correctly. So please keep these records. You, of course, may use a third party. Just make sure that when you do use a third party, that there is a it's got to be a reputable organization, because that records must be accessible when requested by the FIC. You should also inform the FIC if you make use of third-party record keeping at the end of the day. Okay, records can be kept paper-based or electronically, but if it's, of course, electronically, must be reproduced in a legible format, and make sure, very important, that the quality of the documentation is of very high standard, especially when we are asking for copies of IDs or passports. Please just don't accept where you can't even see who the person is. Okay, so the documents needs to be in good conditions. We spoke about third-party record keeping. And just remember that if you do use third-party record keeping, that normally means that if you look at I'm keeping records off-site that I don't have access to immediately. I need to, for an example, use a Metro file. Somebody picks up my stuff, it goes somewhere. I need to request the information from them. Then there needs to be a solid agreement in place, and you need to inform the FIC. Okay. Reports must be submitted. Cash thresholds, ladies and gentlemen, 50,000 Rand. You know that. What is cash? Cash is coins, paper money, and traveler's checks. Physical cash received and paid out by the accountable institution to a client must be reported to FIC. And of course, there's been some change. As we said, 49,999, 3 days. Please, ladies and gentlemen, know that when people deposit cash into your account, you still need to report. Yes, the bank will, but you are also an accountable institution. You also need to report. We're not talking about electronic transfers. We're talking here about cash. Okay. Of course, you need to report suspicious activities, you know, to the FIC. We're going to delve into that a little bit later. Reporting, and of course, terrorist property reporting also needs to be reported to the FIC. You, of course, can have multiple reports under one transaction. So it might be that it's a cash transaction and it is also a suspicious transaction or activity. It doesn't just have to be one. Multiple reports can be done. The definition of non-compliance: any act or omission resulting in failure to comply with the provision of the act or in any order, determination, or directive made in terms of the FIC, and which doesn't constitute an offense. Okay, if we look at those things, administrative sanctions for non-compliance, caution not to repeat the conduct of non-compliance, reprimand, directive to take remedial action, restriction and suspension of certain specific business activities until you've fixed everything at the end of the day. And then, of course, if you are very much non-compliant, a financial penalty not exceeding 10 million for a natural person or 50 million for any legal person. Some more examples. If we go, failure to identify persons, failure to keep records, failure to register, failure to provide ongoing training, failure to perform customer due diligence, failure to create and implement an RMCP, failure to comply with the duty relating to governance, that also falls into that non-compliance phase. And then, of course, there's something which we refer to as non-compliance offenses. That's, of course, a little bit more serious, because here we won't just be in a position where we will get an administrative sanction, but we might also get time in prison. So that's, for an example, if you look at the top row: destroying or tampering with records, misuse of information, failure to submit suspicious transactions. You can see that goes up to 100 million or 15 years imprisonment. And then at the bottom, failure to appear for questioning, willfully providing false information, and failure to appear when summoned, and failure to answer fully and truthfully. You're looking at 10 million or 5 million imprisonment, possibly. On the left, we spoke about that. I just want to highlight that as an individual within an accountable institution, you can also be held accountable if you do not report suspicious or unusual transactions. If you are doing transaction and helping somebody to do business within your organization to avoid a reporting duty, if you're willfully destructing or tampering with records, and if you deal with somebody that's on the United Nations sanctions, you look at those lists. If you as an individual do that, you will be held accountable as well in your own capacity. Just almost finished. I just want to finalize. Please remember, 50,000 Rand, 3 days, cash. Suspicious, there are some examples, ladies and gentlemen. This will be shared with you in any case. Don't want to go through all of that just due to the nature of time. But that's that gut feel. If clients are using vague or contradictory information, a client's business or source of funds are ill-defined, a client who uses financial institutions which is located far from their home or workplace, it's just things that doesn't make sense. You need to communicate that with you need to be able to also teach your employees and highlight to them what might be suspicious. There's some more indicators. 15 days to do so, to report a suspicious or unusual transaction, or of course an activity as well. There's two. There's an activity and there's a transaction. So the activity might be something that's leading up to the transaction when doing a report. Property, 5 days. So if you are, if you become aware of the fact that you have property relating to terrorist funding when it comes to clients, 5 days. It's a little bit of a different approach there. As you can see there, property relating to terrorist activities, the director of the FIC may direct an accountable institution which has made a report regarding property associated with terrorist and related activities to report at such intervals as may be determined in the direction that it is still in possession or control of the property in respect of which the report has been made, and any change in the circumstances concerning the accountable institution. Okay. And then, of course, TFS list, they will be on there as well. That's just a summary how to report. Very important as well, just to know that FICA has 10-day intervals. And then also, somebody that reports in good faith, no liable or legal action will be taken against that individual. Very important. And then lastly, ladies and gentlemen, whoever the money laundering officer is, please make sure that you do these 7 things. Make sure that you are registered, that you have an RMCP in place, that you do training, that you maintain your RMCP, that you verify client risk ratings, source of funds, you submit reports, and then, of course, you as the FIC money laundering officer will also liaise with FIC. Thank you very much. All the best. If you need any help or any more assistance on this topic, please do reach out to LexisNexis. Thank you.
Thank you so much, Cedric. It's a mouthful. It's a book full.
Yeah.
I'm sure we would be able to. There's a few questions, so I'm going to quickly hop over to Vanette just to take us through our screening options that can assist with your screenings, as well as the onboarding of your customers, whereafter we hopefully will have time for 1 or 2 questions. Thank you once again. Vanette, over to you.
Thank you very much from my side. So Cedric spoke about mitigating risk, and we at LexisNexis have solutions to assist you to uplift these risks for your company, firm. So you will also see that there was just a pop-up that you can just, a poll where you can just choose if someone from one of the account managers can contact you with regarding these solutions. So Lexis KYC specifically is an online solution that basically taps in with data sources, verifying identities, contact details, as well as we call it our world compliance. That is the global sanctions, the PIPs, the PEPs. It's an online solution that you can register with us. And then specifically speaking to the Directive 8, which Cedric also touched on, we've got the Lexis RefCheck solution. So that is a background check. Some of the checks that we do is the, just touching on a few, is the criminal records, your matric and academic qualifications, driver's license, your social media checks. So these are some of the solutions that we can offer to assist you to be compliant. And then also we do offer batch uploads where you can give us the information, we can upload it from our side and assist you to get the results quicker. Thank you so much. And then just at the bottom, there's a little nugget. So you would have to do 141,000 individual KYC verifications to pay that huge amount fine. So best is reach out to us. We are here to assist and guide you. And then, yeah, thank you so much. Over to you, Melinda.
Thank you, Vanette. Cedric, we have a few questions. I think I'll start off with the one that was submitted last. The question comes from Victoria Thompson asking, is there a transaction limit under which a client would not be required to be FICA'd, i.e. a client whose account won't come to more than 35,000 Rand?
Yes, 5,000 Rand. I hope that answers the question. If the transaction is lower than 5,000 Rand, then there are certain requirements when it comes to the risk rating and due diligence process that are exempt. But please do also note that it's not to say that it might not be a reporting, because 5,000 Rand might also be a something suspicious, but there is certain exemptions. So that amount is 5,000.
Thanks, Cedric. Quick one. We are an accounting firm providing tax and accounting services, bracket submission of returns and advising. We have registered and have a FIC number now. What? Are there annual submissions or some sort to be done?
At this moment in time, okay, what now is, yes, we've registered. Wonderful, great. Thanks for that. Now, of course, one needs to go and introduce the actual implementation of the Act within your organization, and that's everything that I've tried to cover in a very short time. So you need to make sure you have an RMCP and all of those things. Being an accountable institution throughout the year, the FIC might reach out to you for certain things. But then, of course, there are directives as well that needs to be completed. And depending, of course, in what sector you fall, it might be 6, it might be 7, then you need to complete that directive. But the FIC will communicate that with you. That communication normally goes to whoever the money laundering officer is within the organization. Okay. They can decide. Unfortunately, we don't know beforehand. Last year, we had directive 6 and 7. This year, there was no directive. Still a lot of people that haven't completed last year. But this year, there was no additional information, but nothing stopping the FIC from doing it again next year. Okay.
Thanks, Cedric. See, there's quite a lot of people admitting. On the part of training employees on RMCP, if, say, you have financial advisors who are not under your employ, but render financial services to clients under your license, having that they are not employees of the business, but operate as some form of independent brokers, should they also complete RMCP training, as they are the ones who deal with clients?
In my short, yes. My understanding is if we look at financial advisors, whether, of course, let's not look at corporates. If it's corporates, it's corporates. They will follow their process. We look at IFAs. You are either employed or you are mandated by the FSP under a mandated contract to work there. Might even be that you are a juristic representative on that FSP. But nonetheless, if you're dealing with that clients, yes, everybody should be trained on the RMCP.
Thanks, Cedric. I'm going to go with one more in the hope that we will not be cut off. Good day, Cedric. 31 of the FIC Act in effect. I thought it has not yet come into effect.
Yes, it is it came in effect last year. So yes, it is fully in effect. Yes.
Thank you. I think this is where I'm going to call the stop. For those of you that have submitted, these questions will be attended to and we will reach out to you. The last poll have just appeared. I would want to take this opportunity to say thank you. Thank you, Cedric. Your value specialist knowledge and understanding is making our lives easier. And I could see that there's a light at the end of the tunnel. The tunnel is not getting smaller, it's getting bigger, but we do see light. So thank you for offering that to us. As LexisNexis, we do value our customers and always want to see that they are informed and they can make informed business decisions. I would like to say thank you to everyone. Have a great afternoon and hope to speak to you soon. Bye, everyone.
Thank you. Thanks.